Ready? Exercise number 15 and 16, legal matter, start. A letter dated 28 to 2015 was communicated to that effect to the appellant. Further, when the appellant company asked the respondent/SIE to select an arbitrator from a panel of three names sent by it, the respondent/SIE, via the letter dated 23/7/2015, informed the appellant that as much as there is no binding contract that came into existence between the parties, the disputes cannot be resolved by the arbitrator. The appellant herein, having regard to terms and conditions of contract, invoked the arbitration clause by proceeding dated 2/9/2015 and appointed the second respondent Sri C.R. Pradhan, who was the former chairman (CMD) of the company, as an arbitrator. The learned arbitrator initiated the proceeding by issuing notice dated 7/9/2015, asking the appellant as well as the first respondent to attend the preliminary meeting on 9/10/2015 at Bhubaneswar. Next para. On receipt of such notice issued by the arbitrator, the first respondent herein approached the civil court and filed civil suit number 2610 of 2015 on the file of Senior Civil Judge Gurgaon, seeking relief of declaration that the appointment of second respondent as a sole arbitrator is null and void. Further relief of permanent injunction was also sought, restraining the arbitrator from proceeding with arbitration proceedings. Pending suit, interim injunction sought for is rejected by the learned trial judge, that is Senior Civil Judge Gurgaon. Stop. Next para. Against the order of the trial court refusing to grant injunction orders, the first respondent approached the district court, the appellate court, that is the additional district judge Gurgaon, via the order dated 25/1/2016, allowed the appeal and granted the injunction, restraining the second respondent arbitrator from proceeding further pursuant to notice dated 7/9/2015, when the appellant herein has questioned such order by way of civil revision number 2471 of 2016 before the High Court of Punjab and Haryana at Chandigarh. The same is dismissed via the order dated 22/10/2016. Hence, this appeal by way of special leave. We have heard the Sri Ashok K. Gupta, learned senior counsel, appearing for the appellant, and Sri Manoj Swarup, learned counsel for the first respondent. Though the second respondent is served, there is no appearance on his behalf. We have perused the impugned order and other material placed on record. It is the case of the appellant that as much as the appellant has accepted offer/tender submitted by respondent, it is a concluded contract and is an arbitration agreement within the meaning of Section 7 of the Arbitration and Conciliation Act 1996, under bracket for short the act bracket out. Next exercise. On the other hand, it is the case of the respondent as acceptance was not unconditional. It does not amount to a binding contract between the appellant and the first respondent. As such, the arbitrator has no jurisdiction to decide the lease between the parties. Mainly, it was a case of the appellant that, as much as the acceptance of the bid will conclude the contract and having regard to terms and conditions of NIT and general conditions of contract, it is a binding contract between the parties. As such, dispute is to be resolved only by way of arbitration. The learned counsel for the appellant has placed reliance on judgment in the case of Kavirner Cementation India Limited versus Bajrang Lal Agrawal and another. It is a case of the appellant company that even if the first respondent disputes the jurisdiction of the arbitrator, it is open for the first respondent to move an application before the arbitrator under section 16 of the Act. But at the same time, the suit filed by the first respondent for declaration and injunction is not maintainable. In the judgment of this court in the case of Kavirner Cementation India Limited versus Bajrang Lal Agrawal and another, this court has examined the similar issue and held that any objection with respect to existence or validity of the arbitration agreement can be raised only by way of an application under section 16 of the Act, and civil court cannot have jurisdiction to go into such question. Having regard to aforesaid judgment of this court and various communications between the parties, we are in agreement with the submission made by the learned senior counsel for the appellant that if the first respondent wants to raise an objection with regard to existence or validity of the arbitration agreement, it is open for the first respondent to move an application before the arbitrator. But with such plea, he cannot maintain a suit for declaration and injunction. Though the trial court rightly rejected the interim injunction sought for by the first respondent, the same is erroneously reversed by the learned additional district judge, and such order is confirmed by the High Court by the impugned order. As we are of the view that the order passed by the additional district judge and the High Court are not in conformity with the law on this subject and are contrary to judgment of this court as referred above, the impugned order is liable to be set aside by vacating the injunction orders. Stop. Thank you very much.